Good evening, ma'am. Madam Amita Dhanda, ma'am. Good evening, and thank you for accepting our invitation. And we are very much going to be enlightened by your lecture, ma'am. And sorry for the interruption regarding the technical aspect as such. And now I request the Vice Principal Radhika, ma'am, to introduce. Today's resource person, Professor Amita Dhanda, ma'am. Please, Radhika.
Done all these years to all the participants so that they'll get acquainted with Professor Amita Dhanda. Ma'am has been on an before joining the NALSAR, she was associated with the Indian Law Institute, Delhi. Ma'am has written extensively on the legal position of persons with mental disability, legal order, and mental disorder. Her book on the legal status of persons with mental illness is a pioneering effort in the field. The Government of India and the Supreme Court of India have utilized her services to suggest far-reaching legal and policy reforms in the field of disability rights. She is assisting the government of Gujarat in formulating a rights-sensitive mental health law. Her research expertise has been drawn upon by international and national institutions such as WHO, UNICEF, NHRC, NCW, NIMH. At present, of course, Professor Amita Dhanda ma'am is strengthening the research base of law reform and legal education by actively engaging with policy and law in the field of mental health, child rights, disability, and environment. Thank you, ma'am. Thank you. And now I request you to take over the lecture. Thank you for accepting. Thank you, ma'am. Welcome again to this platform.
Thank you, Radhika. Thank you so much. So basically what I want to speak with you all today is on how to do original research in law. It may look like at some level that what is this topic that I have chosen? And because I was told that the people who are attending is like LLM students, doctoral students, and of course, colleagues working in the field. Why is it that I am thinking this is an important issue to be discussing in a research methodology workshop and a research methodology workshop in relation to law? Firstly, of course, because the expectation from all of us when we are doing research is that we will be making an original contribution to knowledge. And because there is this expectation that we will make this original contribution to knowledge, very often law people, more than in other disciplines, have a problem in doing that. And that's the reason why I'm going to be spending time on discussing this particular issue with colleagues in the legal fraternity. Next slide, please. So the scheme of my presentation, how I'm going to be sequencing what we're going to do here is that I want to be looking at, firstly, what is the special challenge of doing original research in law? Why is it that I am trying to highlight this as an explicit topic that we should think in terms of? After talking about that, I'm going to be making this link between methodology and perspective. That is, as to how do you look at law? What's your way of seeing the legal discipline as well as the legal institution? How much of that influences the kind of research methodology that you need to adopt? I'm especially then looking at the critical approach, which is inherent in positivism, but we are so very intent on the information dimension of positivism that this critical approach or the kind of critique which positivism has developed, we do not spend as much time on. I then look at that, okay, how, if you start looking at the interconnections between various disciplines within law, and which is why I'm calling it the intra-disciplinary options. Like if you look at the connection between, say, criminal law and constitutional law, or between family law, constitutional law, and criminal law, or you start looking at constitutional law and corporate law. These are kinds of connections we don't often make. We tend to do this specialization. That is, what is it that we are, our own area of specialization seems to drive our research. Hence, I'm looking at the options which interdisciplinary research gives to be doing original research. And lastly, I look at interdisciplinary possibilities, which is relatively, I suppose, the more accepted kind of angle that nearly everybody knows about, that, okay, if you are doing empirical work, if you are doing, a combination of your discipline and law, then hence of the law and some other discipline, whatever it may be it psychology, be it sociology, be it philosophy, then the chances of your creating something new is more easily conceded. But ordinarily, all of us don't really go into doing what you would call as either empirical research or even interdisciplinary research. It's not the preferred mode in which how we do research. But that's the last slide I come to. And so let me begin from, what is the special challenge of doing original research in law? See, the way in which we look at law is like all of us, in the way in which we've been trained. We sort of somewhere believe that the institutional sources determine exactly what is law. By institutional sources, I mean that you will look at, the whole phenomena of that, okay, the legislature makes law, so legislation is law. The judiciary makes law, and hence, and especially if you're talking in terms of the superior judiciary or the appellate judiciary, you would then say that, okay, courts make law. A certain amount of power that is given to the executive, administrators make law. So this is the usual kind of package that we turn out, that we will talk about the relevant legislation in an area, we look at the relevant case law, if there are rules, regulations, notifications, orders, which are of some relevance depending upon, say, like tax people will never ever teach their discipline without looking very closely at subordinate legislation, because subordinate legislation somewhere drives that area of law much more than others. The point I'm somewhere trying to put forth is that this information which comes from these institutions, in some way, imparting that information becomes a very major part of legal education. And these are all institutions which hold power, hold authority. What they say as such, it being law, we kind of start to adopting a pretty uncritical attitude towards the legal discipline. So whenever you are asked a law question, you'll be tending to say, this is what the Supreme Court of India has to say, or this is how Parliament has regulated the matter. I mean, we don't even look very much at state legislations, but if you do too, you still do not really sever, this connection between authority and what is law is not something which we are really taught to do. So what tends to happen because of this way of doing things, collecting of legal information rather than critiquing the choices we have made becomes the way in which we do legal research. So you'll pick up a topic, you'll talk about you pick up any topic, you'll say, okay, I'm going to look at minority oppression in company law, say. So you'll look at what the provisions are in the Companies Act, you look at all the case law which comes in, you'll try, if you are being you're being very hardworking, let's say, you may look at what other jurisdiction in other parts of the world, how are they addressing the question. The fact that you are looking at all of these pieces of information, what is in fact happening is you're just compiling. You're compiling and you believe that, because this is an authoritative source, this institutional source is so authoritative that you don't think that you can be doing very much more in terms of critique. And that kinds of, in a great way, when you start to believing that collecting of information, because it is scattered and you pulled it up together, what is the original contribution you've made? Really speaking, nothing. But the fact that this is coming in from authoritative sources tends to have this influence on legal scholars that you feel burdened by, or you feel imposed upon by these institutions. So you don't as much critique them as comment upon them or collect what they have to say. At the most, you will say, oh, if the judge, instead of saying this, that, had said that, this, like some level of very minor level commenting you might make, but you do not really sit and critique what they are doing. Before the internet and digital databases and stuff, one could say that, all right, even this collation was doing some kind of contribution, because it was so very difficult to put together up-to-date information in relation to what's happening in law. But as, like with digitalization, with the whole range of, it's like a Supreme Court decision happens today and within hours you would know what has happened there. So, and as a result of which, the kind of contribution, individual collection, or individual collation makes has come down hugely. I can say that in my, like when I was pursuing my master's and when we were kind of carrying on research, the sort of, the sort of ease with which you can get information was not available to us. And because it was not available to us, the very person who was kind of very adept in keeping, or had sources from where you could access this information was someone who called, some level of cutting edge in the whole functioning of legal academics. That's no longer the case for you. Information is literally on a click. If information is on a click, then research cannot possibly be just about collecting that information. You have professionals who are doing a way better job on that count. At the same time, when you register for a PhD, one of the conditions for being awarded a doctorate across universities is that you are making an original contribution to research. And because this is the kind of demand that you're making an original contribution to research, it becomes imperative for all of us who are doing research to sort of like engage with this question of that, okay, what is the contribution I am capable of making, and what is the contribution needed in my particular area of research? I would put to you that large amount of methodology. It was fine. Please, the new slide was all right. That there is this whole question of the needing to make a link between methodology and your perspective on how you look at the law. Ordinarily, and this is connected with because of the fact that a lot of, we feel very overburdened by all these institutions we are carrying on our shoulders. We very often do not ask. We'll say how the court looks at it, how the legislature looked at it, or how the executive looks at it. We don't really ask, how do I look at it? What is my way of looking at the law? What is my perspective towards looking at the law? So my first, if one was to see is as a range of hacks that I'm giving you today for how to do original research, and the first question I will put to you is that you need to be asking yourself, what is my perspective? How do I look at the law? What do I see as its dominant objective? Do I see this basically as an instrument which is available to the state for it to discipline the people? And hence, if laws are made to get people to behave, for order to be maintained and upheld, then law has fulfilled its function. And that's my only critique would be if the law fails or succeeds on that count, right? The other way, of course, of looking at the law, I could be seeing it as that, no, the state is anyway all powerful. So I am looking at whether law is protecting the rights of the people. It's like when you are coming up with any kind of legal intervention, are you in any manner, what I would say as enhancing, or let's say that, am I, before the all-powerful state, am I protected by the law, or has the law virtually thrown me over into whatever the state wants me to do? So then every legislative intervention I'm trying to see as, is it expanding the power of the people or is it reducing the power of the people? You could have a third kind of a perspective, which is like where you don't see the state and the people in opposition with each other. You in fact look at it like that today I may be the ruler, tomorrow I may be the ruled, but whether I am ruler or ruled, I need to be like I am, because in the Aristotelian definition of a citizen is one who's both ruler and ruled. The point I'm somewhere trying to make here in putting out this particular slide is to bring home to you that a large part of critique in the first instance develops from how you look at the larger legal system. It's like if you are, you have almost convinced yourself, or you have been given this position, that if there is a position being taken in by, say, the superior judiciary of this country, then all of us are just meant to memorize that position. We are not meant to question that position. And we would memorize that position if we sort of see law as a kind of a disciplinary mechanism, if we see ourselves not as citizens, but as subjects, as people who are just to be knowing what is happening. We don't need to be querying what is happening. And this particular business of methodology and perspective would come in relation to, I have given you one level of examples, but you could ask that same sort of question in so many other ways, what is the rest of my presentation, or at least the next one, where supposing if I look at the law as a feminist, then I am looking at every part of that law as to, okay, what is it doing to people who are socially disadvantaged? What is it doing if there's a whole social ideology there, then how that ideology is impacting on particular kind of people? What is the legal instrument doing there? So if I have to summate this entire slide and not, please don't change the slide before I ask you to. If I have to summate this slide in terms of what is the point I'm trying to make across, these are, like what you perceive as dominant objective, and how do you look at the state or the people, or whether we have some kind of special role in relation to citizenry. For me, that's more like an exemplification I'm giving you on this connection between methodology and perspective. So the most fundamental question I'm asking you is that every time you encounter any legal instrument, the first thing that you need to be doing, so the first question that you need to be asking yourself is primarily what your own perspective is. We have been in the discipline of law so very much taught to think in terms of institutions and what they have to say, that we are not really trained to ask the question on how do we perceive it, and how the people who were involved in these various transactions, how did they perceive a legal question? But I am, in my opinion, your methodologies and your perspective and your methodology are very inextricably linked. So when you want to do research, the first question that you need to be asking yourself is, what is my perspective on this question? Which school of thought do I really subscribe to? And once you have settled that up, then methodology sort of like follows from there. Next slide, please. Because of the fact that we have this huge stranglehold of positivism in how we operate, or how we kind of carry on legal research, we somehow the other, and this is linked up with what I was saying in the previous slide, that we tend to believe that what is coming in from these institutions is like, because it is the law, and not on how it ought to be, but what it is. Positive is about law as it is and not how it ought to be. Hence, we often believe that there is, really speaking, no space for critique, and consequently that entire compilatory or collatory way of doing research. I would sort of like put to you, and it's important to say that because a lot of us have been positivism bashers. We believe that, oh my God, this positivist way of doing legal education has made for uncritical legal scholars. Us law scholars don't ask enough questions, those kinds of things. Whereas actually what happens is that positivism has elaborate rules on, what should be categorized as law, be it as legislation, be it as administrative regulation or adjudication. Just to give you one example, let me take one from each of them. When we talk in terms of legislation, the very fact that your legislation has to be in accord with the Constitution, the very fact that there is this the control that the fundamental rights put in relation to what you can't be making a law which is in breach of your fundamental rights. The very fact that, like this legislation, it's like if you're talking in terms of that there's a specialized area on which you are making a legislation, then you can't, and your general legislation and your special legislations, what is the relationship between them? The special is supposed to prevail over the general. And so whether your particular area is a specialized area or is a general area of law, all of that becomes relevant in what you're going to be seeing as something which is you're permitted to do or not to do. Similarly, when it comes to adjudication, the whole realm of, like the fact that a larger bench has made a decision in a specific area of law, a smaller bench can't go and change it. That's the positivist way of understanding the whole phenomena of precedent in a common law country and what should be done or not done. Similarly, when you look at rules and regulations, it is like you can't really make rules and regulations which are in breach of what the statute has authorized you to do. If you're having a rule which is in some manner going counter to what the legislation is saying, then that itself becomes an entry point in terms of critique. What I'm trying to put forth is, it is not like positivism doesn't have a critical way of looking at its outputs. But unfortunately, we don't use the critical rules of positivism as sharply as the information dimension of it. And it's important that if you are taking a positivist approach towards the point I was making in the previous slide, that there is a very inextricable connection between perspective and methodology, then you need to be very, very clued in with all the rules, the internal critique rules that have been made in the positivist school of thought, by which you say, if an institution is of a particular kind, then this is the manner in which it means to be operating. If you are, even if you're supposing like taking a more activist approach as a judiciary, what is it that you have? What are the kinds of norms that say the Supreme Court of India has created for what an activist judge can do or cannot do? Large number of decisions which are coming in from the court today, we could very ably critique by picking up the very standard norms which come in relation to questioning adjudicative output. In terms of doing original research, it virtually becomes that, say, I decide that I am a black letter lawyer and I am going to be looking at legal output purely as a black letter lawyer. Then it's extremely important that I am a deep black letter lawyer. And a deep black letter lawyer will not only look at legislation. We'll look at legislation, we'll look at rules and regulations, we'll look at the adjudication, we'll look at stuff which is like influencing the circulars and the notifications and the orders. Everything which is kind of has a relevance or an impact on a specific point in law, you need to be in full grips with it. And then you need to be looking at what is their inter se relationship. If we are going to be saying we are positivist scholars. But in that also, I am only going to be looking at a particular area or a specific issue or one particular legislation and not look at all the other outputs which is coming in from there, then necessarily I'm one half-baked. Two, what I am not doing is I am not really looking at the areas of law, or let's say the principles of law, which give me the opportunity of mounting critique. And if I take that opportunity and I mount critique accordingly, I am then on the way to doing something which no one else has done. Unfortunately, it's like, sort of, I'll just give you as one of the examples, which Professor Faizan Mustafa had done this very, very interesting presentation for us at one of our own research methodology workshops. And he was saying that, before your Article 370 was abolished, and this is like, this is the time when we did it. He's saying that, everybody is talking in terms of the exception which has been created in relation to Kashmir by Article 370, and hence you are saying this exception making should go away, and for that it's important for us to repeal 370. His point somewhere was that if supposing this is the proposition that is being made, that 370 is exception making, then it's important for you to know exactly in what is it providing exception for. And then he was speaking in terms of the range of orders which have come in from the president by which you have hollowed out 370, and literally speaking through presidential order, that which you could not, like your legislature cannot extend something to Kashmir, but through executive orders, through presidential orders, you have gone and you have kept on extending those particular provisions to Kashmir. Now, what is happening here? He's not really moving out of an entire positivist methodology, but he's saying is this: if you are really going to thoroughly study Article 370, you can't just look at 370, and you can't just look at the bare text. You also need to be looking at the other orders which are coming in from other articles by which you have, in effect, whatever sort of concession was given by Article 370, you've cancelled out by something else. The moment you start to be looking at all of legislative output, or want to see the relationship between the constitution, the legislation, and rules, regulations, you are very much within positivism, but you are not kind of looking at the positivist functioning in an uncritical kind of manner. And I think that's a very significant dimension of what we often don't look at. Okay, I'll give you another example. Say you're looking at adjudication. What do we look at when we're doing adjudication? We largely look at the judgment. We look at the final product which has come. Now, if I am saying I am only going to be looking at legal materials, then the petition is a legal material. The arguments which happened in court is legal material. Maybe very often you may not get, SEC at some point used to sort of like give a brief of the arguments which happened in court. In the traditional way of writing judgments, judges were meant to record what was argued before them in court, but nowadays very often they don't do that. The point I'm somewhere trying to make is this, that if you look at, say, what was the petition, what is it, how did the person who was defending the petition, what did they have to say, what was it that came before the court? If supposing an argument was not made in court at all, then can we really be blaming the judges for what came through? Or supposing an argument was made in court, which if it had been listened to, you could have got a very different kind of judgment. The fact that we are content with just looking at the final product, which is the judgment, and we don't really look at paper books, and we don't look at all significant other materials which is the basic input from which the judgment has come, is the reason why the sort of research we'll end up doing becomes a very recycling kind of thing. This is what the judges have said. And then we sort of, in our own words, say, this is what the judges have said. We haven't really looked at, okay, what is the process which informed the judges in saying what they said? The moment you start to, there's a basic rule, no, in terms of judgments, that you can only write the judgment on what was argued before you. So you can't really assess whether the judge has done a good or a bad job if you don't look at what was argued before them. It's like, as black letter lawyers, we are not just, we are not being ambitious enough. We are not even looking at all the black letter materials. If you look at all the black letter materials, automatically amongst the things which ends up happening is that you are, the stuff that you're looking at is wider than the stuff which is ordinarily available before people. And necessarily the sort of analysis that you will come up with would be of a different kind. When we do legal research, unlike, I would somewhere actually even include this in when we do legal education. Because if we were to educate in that manner, then I suppose we would open up our students to understanding what are the various kinds of processes which have informed the final output. And I am putting to you, especially when you are doing your, your doctoral work or your LLM, even your LLM dissertation, don't be, like if you're only looking at a legislation or only looking at the judgment or maybe however many judgments, but you're not looking at least for all the landmark decisions, what is it that got argued? What were the facts which came in? The petitioner who came before the court, why did they come before the court? All of this material is very much available within traditional black letter materials. The moment you start to look at that full range, you have opened up yourself to the opportunity of being able to analyze a situation from absolutely, what would I say, from a very novel stance. And I'm not in any which way, when I go to the next two slides, I am going to be asking you to look at materials other than law. Not in the next slide, but the slide after that, the final slide. But herein, I'm only saying is this, that if the positivist way of looking at is to say, whatever comes in from the various institutional authorities, whatever their output is, that is law, then it becomes extremely important for us to, in some manner, not be content with the most easily available of those materials. We need to be sort of making a case for that the entire process needs to be looked at. So you look at a legislation, you can't just look at a legislation. If it has gone through, say, select committees, or if it has been looked at by, or memorandums have come from citizens on what they wanted, all that is very much part of the whole process. But somehow or the other, that's what we are cutting out, and we're only looking at outputs. If you were to look at the process and then look at output, each person who examines this entire thing is going to make a contribution towards our understanding of legal materials or legislations and case law, which is not easily available. That's a different thing altogether. But more importantly, these materials allow for a range of interpretations to happen. And with varied interpretations coming in, you necessarily have a more original kind of an understanding of how the entire legal institution and its outputs, or its how the range of legal institutions and what they do with their power happens and what is done or not done. I'm literally only, I suppose if I have to again reduce it to one point, I would say what I'm asking you to do is, do not be content when you are doing legal research to only look at the standard, everywhere available kind of material. Look at also the processes which informed the making of that material. And the moment you start to do that, you will bring to light whole perspectives and information even, which is not commonly available. You would start to sort of create, patterns and designs which are not available. And in a large extent, that's the original contribution you can be making. The moment you start to say, okay, such and such could not have been held by the judge because nobody argued this particular process. This particular contention was never made. Or if you start to say this contention was made and yet the judge has come to the decision he has come, look at the way in which the critique is happening. It has started to change color. More importantly, all the players involved in the process of adjudication have come on board, and you're not just concentrating on what the judge in his final judgment has made. You're also, it's like that judge and co kind of thing. You're looking at what the judge has to say and what people had to say to the judge before a final decision. Okay, next slide, please. The point I'm trying to make somewhere here, see each of these, if I was to comment on my own presentation, what I'm trying to do with you is this: I am questioning our usual way of doing things. And I'm saying that this usual way of doing things will only produce non-original, standard form, known to all research. But if you start altering that usual way or start critiquing that usual way, you open up a whole range of possibilities of being able to produce research which has not happened before, and consequently contribute to legal research taking more original forms. Now, when I'm talking in terms of intra-disciplinary options, what I mean here is that very often you find that, we find it in the master's program. I have been for a long time, at least at NALSAR, been advocating very majorly that we don't need specializations at the master's level. We actually need more and more people to be generalists, people who should know about all areas of law and not one particular area. But fortunately or unfortunately, whichever way, we have been making this big case for people specializing in a specific area and hence knowing nothing else excepting that area. So whatever it may be, you may be doing intellectual property, which is supposed to be like one current subject, or you may be doing something even more exotic. But the fact that you're doing the exotic, amongst the things which lands up happening is that you kind of go too soon into a niche area and do not know the interconnections. I am saying is this: when you do intradisciplinary research, then to look at, say, the interconnections between intellectual property and constitutional law. If you have the whole right to speech and expression, and we say that one part of speech and expression is also to have access to information, and if intellectual property is about monopolizing of knowledge, at least traditional competitively understood intellectual property goes that route, then is that whole body of intellectual property law in some way anti the Constitution? Is it unconstitutional? Can it be questioned from there? What are the connections that you see between when you are introducing a whole range of criminal sanctions in economic legislations, or when you are talking in terms of the whole area of corporate law came into being because of the fact that we wanted to limit people's liability. You felt that if you wanted to encourage business, You need to limit liability, and if there is unlimited liability, people are not going to put their own money into economic functioning, economic entrepreneurship, and you want to encourage that entrepreneurship. Hence, you brought in the whole area of, you created the institution, the fictional person or artificial person of the company, and you proceeded from there. And yet now we are somewhere wanting to lift the veil in more and more situations, and you are bringing in criminal sanctions in relation to the officials of a company. What is this relationship between criminal law and corporate law? You can't say I'm only a corporate law person, so I don't look at how criminal law addresses this issue. Or the fact that, if supposing there's a whole range of money laundering that an individual person is doing and is trying to do it through a corporation, does that make it like, because a corporation cannot possibly, can't have a guilty intention, so can I get away with certain sort of things? The only, I suppose I can share with you, my own area of research is my area of doctoral research was in the whole area of looking at the legal status of persons with mental illness or people of unsound mind. Now, one way of looking at it, very often people would believe or think that when I'm doing unsoundness of mind, then I'm looking at Section 84 of the Indian Penal Code, because that's about the only section wherein if you were to look at your entire period for which people are taught law, that's the one section where some engagement with unsoundness of mind happens. So then, if I was to, was my thesis only in relation to criminal law? When I started to look at the whole question of the legal status of a person of unsound mind, I found I had provisions in every single area of law. I had to look at contract law, I had to look at family law, I had to look at how the Representation of People's Act was looking at the matter. How does the Transfer of Property Act, what does it have to say? What does succession have to say about it? It was literally speaking that there wasn't a field in the entire, wherein unsoundness of mind was not a relevant question. I was only doing intra-disciplinary research, and to say, okay, unsoundness of mind, I'll give you one other example. There was this whole question of that you wanted, because we didn't have, in Hindu law, at a certain point of time, you didn't have the phenomena of divorce. You were married for life. And you had this Hindu law committee, which was looking at the whole fact of Hindu law reform. And amongst the things on which they received really, really large number of representations was to allow for nullification of marriage on grounds of unsoundness of mind, to be saying that you have all these young women saddled with insane husbands. And if the committee did not make for this provision, forever they are going to be oppressed through this entire process, because you are talking about that marriages cannot be dissolved. And I think a really, really large number of petitions, at the end of it all, they did include the whole ground of nullity on grounds of unsoundness of mind. And then when I looked at the case law which came under the Hindu law, which was permitting nullity, which was permitting divorce on grounds of unsoundness of mind, who do you think were the maximum number of petitioners? It was not the women with the insane husbands. It was the men who were wanting to get rid of their inconvenient wives. And so where were the women? What happened there? And suddenly when I was looking at, and I'm not saying, I'm just trying to tell you that when you start to do interdisciplinary, that is, you not limit yourself to any one area of law, but you start to see the interconnections between these areas. What is it that arises? Where is it that I found the women? When I was looking at the defense of insanity, and I was looking at, okay, who is the single largest victim of whoever was seen to have committed crime in a state of insanity? The single largest victim was the wife. And when it was wives and children who kind of scored highest in Section 84, and when I was looking at decisions which are happening, or people who are the people who are activating the divorce law or the law of nullity on grounds of unsoundness of mind, you found that it was a very different kind of a trajectory. Now, these were, I'm not saying in any which way that, you know, like this is some empirically the most rigorous kind of research. What I'm sort of somewhere saying is you really couldn't understand the status of a person of unsound mind or how the law perceived this issue or how society perceived this issue by, say, just looking at 84 or just looking at the marriage law or just, but when I saw them all together, the kind of pattern I was able to weave is something which did not exist till I saw those connections. Because fortunately or unfortunately, when we teach by specialization, no? So like you'll be taught contract law and you'll be taught criminal law and two different teachers will be teaching it. But when you research, you can actually look at the interconnections between areas of law. And the moment you start to look at those interconnections, one, you obtain, whichever issue you have taken up, you obtain a major depth in the understanding of the issue. And more importantly, you can actually create formations. You can create connections which did not exist before somebody sat and did that connection making. So when I'm asking you to take intra-disciplinary options, you still haven't moved out of the discipline of law, but you have moved out of specializing too soon. Because if you specialize too soon, what tends to happen is that, you know, like specialization usually moves like this. So you picked up this field and you've dug deep, deep into it, but you've not seen that, okay, this particular hole that you have dug for yourself, how does it kind of branch out or reach out or connect up with other areas of law? And that is the critical, the moment you start to do that, you have in effect got onto this route of creating or finding something which did not exist till you found it. My theme as such has been on, you know, how to do original research, and each one of the entry points I have given you. I gave you the first one I gave you was look at your perspective. The moment you look at your own perspective and create your own methodology, you would be able to do certain things because you are not looking at other people's perspective. You're looking at your own. And your own is not something that anybody else could have legislated on. So necessarily, you've got yourself an entry point, which is new. I had then spoken with you on the whole business of positivism, and I said we concentrate too much in positivism on information. We don't really look at the authenticity of that information. If supposing somebody is making a claim, how valid is that claim is something we don't concern ourselves with. I gave you the Article 370 example for that purpose. This intradisciplinary options I'm making on is that if you do not, irrespective of which topic you are picking up, the moment you kind of take on this whole question of intradisciplinary options, what you all, in the whole positivism thing I was saying is, so what you are in effect doing there is that you have, where the claims that people are making, you are in some manner, Dr. Prashanath, I can't really see what's the relevance of this question in the context of what I'm speaking. Because it's a very specialized area of international law on which you are asking questions. I am talking more in terms of how you could be doing original research. If you are trying to say to me that because whether the US Supreme Court and Indian Supreme Court should have oversight, I think for me this is a very naive way of looking at courts and believing that they are in some way not political institutions. And if at this point of time, if you see your own court and how it is operating, it is kind of demonstrating to you in plentiful terms. So I'll come to your questions. I come to my last slide and then I can sort of open it up for questioning. Though I would somewhere, like you need to be asking a question which connects up to the presentation which is happening. So making a generic kind of a point, and I would somewhere think that the position you are taking is very naive, because you actually seem to believe that courts are in some manner a more objective kind of an institution than other political institutions are. What I would put to you to consider is courts are as political, and of course in the US even more than in India, but in India no less. And the manner in which our own court has been operating in relation to all major decisions in the recent past, can you be actually saying that they are behaving like a court which is not political? This is as far as when I spoke about the interdisciplinary options, I was speaking in terms of, and I gave you the example of my own research as to how, though I picked up a particular issue, I did not limit itself to any one area of law. So be it public law and be it private law, be it constitutional law or be it criminal law, I saw interconnections between all of these areas and hence was able to do something which did not exist before I did my particular research. So the last slide I have here is what I'm talking in terms of interdisciplinary possibilities. And in that interdisciplinary possibilities, I also said to you that this one is the one which nearly everybody would very easily concede to, that, okay, if you want to do original work, you do work on not just in the area of law, you kind of look at law and law itself being a superstructural discipline. You try to understand that, okay, if a specific kind of an outlook has come in the law, then which areas of, say, criminology influence the kind of provisions you have in criminal law? What kinds of perspective of patriarchy have brought in, say, provisions in relation to status of women in the law? So the fact that the moment you are moving outside of law and you're looking at the positions taken by disciplines other than law, you're forging these connections between law and you could also be very often creating a whole new area. So when we speak in, say, supposing the whole area of disability studies or women's studies, you can't really say disability studies it kinds of draws from law, it draws from social sciences, from culture studies, you name it, and they're all kind of coalescing into a whole new field in which something is happening. The moment, and what is very, very important for us to somewhere appreciate is that when we are teaching, I think it's Ataya who says some point in his book on the law of obligations, who says that when you teach, you necessarily have to, create these pedagogic specializations. You have to say, okay, like this is a class where we are going to teach criminal law, and that's a class where constitutional law is going to happen. So you make those kinds of streams in which you teach. Because if you don't do that, it becomes a very, very unmanageable exercise, and you'll have a whole range of students who might be very confused. Occasionally, even in teaching, like very often, so many of us feel that if you were to teach, say, substantive criminal law, procedural criminal law, and evidence act as one package, then the kind of understanding that you may give to students of the whole criminal process is of a different order altogether. But that's something which is coming in with my intradisciplinary. In interdisciplinary, what we'll end up doing is that you start to say, okay, what does penological theory have to tell us? What is happening in the whole realm of criminology? What about the sociology of, like the entire sociology of deviance? So the moment you proceed outside of the four corners of whatever we understand as the law, automatically you create, you forge connections and you create this multiplicity of meaning. And the moment you create meaning or you promote interpretations which are not standard form, which is like throwing the light on an issue from a totally different, angle, then the originality is about that which did not exist before. And evidently, interdisciplinary work has possibly the, or let's say the most accepted sort of connection between original work and interdisciplinarity, or between interdisciplinarity and original work, is the more usually accepted position. The others which I had brought out for you is something we don't usually talk about. The purpose what I was trying to do through this presentation was trying to tell you that escape this very information way of doing legal research. If you want to be doing information searching, then at least do some really great mining. Look for materials which are not commonly there. Start studying files and records and the entire archival material which exists in relation to law. You're going to find that the moment you start to do that, you would have uncovered something which you very often may not even know exists. But it's only in that uncovering, in only bringing out that which people had not thought of before. And for that, you need to sort of leave the beaten track and make your own, blaze your own trails so that you can find things, so that you can show things which exist, but people don't know about it. Make connections which are possible, but nobody has dared do it. It's in those kinds of ways that you can start to do original research. In the main, I am saying be more ambitious. Don't be so easily content. It's only if you do that you can be sort of speaking in terms of making what I would say an original contribution to knowledge. Dr. Nandini, I can see your question straight off, and because it was like speaking right up to what I was saying, I'll just want to, I know there might be a formal thing by the moderator to, see, I don't think that original research is necessarily empirical research. Empirical research is one kind of original research. But when original is that which did not exist before, that which people were not aware of. And from therein, the moment you start making connections which didn't exist before, whether it is in terms of interdisciplinary or intradisciplinary, I would consider both of them to be original. Empirical research, true, is like going to the field and finding certain things. But I don't think it's correct to be saying that only when I go to the field and I go and find something, that's the only kind of research which is seen as original. And also the requirement in your doctoral work is making an original contribution to knowledge. I am saying is fresh meaning creation. Putting out interpretations or providing for, like putting out interpretations with an evidence base which did not exist before is original.
There is a question from one Mr. Saifullah. The question is, Madam, can you please show us the method how to look at any current legal problems, say sedition or problems in GST, from original research point of view with few examples?
See, like I mean, I have been giving you examples throughout. It's evidently I am giving you examples with areas with which I am familiar. So I would say, like, supposing you want to be looking at sedition. Now, if you want to be doing sedition, one way of like is just to look at the provision in the penal code and stay with it. Or supposing you were to look at, if I was to take, say, an interdisciplinary line in relation to sedition, you have a large amount of historical material which exists in how the whole phenomena of the offense of sedition, say, was treated during colonial times. What has changed or varied now? Who are the kind of like players what were the sort? Because see, when in sedition, during the freedom struggle, was put out as sedition by the colonizer, but was seen as fighting for freedom by the freedom fighters. It's important to be asking in today's time that when you are belonging to a segment or section of Indian society, which is not really getting the space that independent India should give to them. I mean, we're sitting in Telangana. A large part of the Telangana struggle came from the fact that, okay, Telangana did not get its due. And for a fair amount of time, a lot of what people were doing as a part of their agitation for getting the requisite space, political space, was labeled and categorized as sedition. So then sedition as such, there is a state's way of looking at sedition, and there is a people's way of looking at sedition. Which is the meaning that you want to be highlighting? Do you see a collision between these two meanings? You have gone out of this entire way of just, like every time, supposing, say, someone is tried for sedition, there is the state's way or the prosecutor's way of looking at sedition, and there is the defense's way of looking at sedition. The moment you start to look at those as competing meanings, you are starting, and you can't then be saying, okay, how the court ruled on it is one part of it. How convincing was the court in how it ruled on it? If you take a purely positivist line, to be looking at the entire line of decisions which came in and to see how consistently the adjudication has happened. These are like the point I'm trying to put forth to you is this, that the moment you expand your perspective, expand the materials you're looking at, start looking at connections which are beyond your particular area of specialization, and also look at what disciplines other than law have to say to it. All of these are entry points into doing research in an original. I have this Mr. Parth's question, which is right here. I don't know, Parth Naithani's, who's saying that while doing the interdisciplinary research on a topic like criminals' liability of unsound mind, how much should one look at psychology? How much one can look at law? Should a person pursuing law take it upon himself to study the psychology of unsoundness of mind? How will the study help in making a legal point? Okay, see, the point I would want to make with you, Parth, is this, that I'm just putting it to you. You can respond and tell me if I'm understanding it correctly. Are you not presuming in the way in which you are asking that question that psychology in some manner possesses some expertise or some kind of special knowledge which is not possessed by law? And hence, if I really want to study unsoundness of mind, I should study psychology, because otherwise I can't really make a very authoritative or a very expert analysis of the whole question. Am I right in thinking this seems to me like the subtext of your question? I don't know, maybe he's asked the question and left or something.
Ma'am, he has said that he agrees with you, ma'am. He agrees with you.
So,
he has said that, yes, ma'am, I agree.
So my point somewhere is this, what I would put to you, and that's at least a large part of the sort of work I have done, is that I am to be saying that, yes, some expertise is possessed is one kind of thing. And to be saying that that expertise has to be deferred to is another kind of thing. The way I would sort of look at it, Parth, is that I would want to be looking at how psychology has addressed this question, but I don't want to or need to become a psychologist to do that. I look at the kind of analysis or the sort of evidence or the kind of contentions that the discipline of psychology is making. But I study all of that very much as a law person, because I can't become a psychologist, but in trying to learn all of psychology, I lose my law also. So I would put it to each person that when you are doing interdisciplinary work, you do it in a manner where you process what the other discipline has to speak to your discipline, but you do not give up the your own groundedness in your own discipline. That need to be grounded in your own discipline is a very critical part, in my opinion, of doing interdisciplinary research. Because otherwise, what tends to happen, you can't see, if supposing something that people have studied over a period of 8 or 10 years or 5 or 7 years in an area, you cannot get that expertise. And if you start to defer, to be saying that this is the kind of literature which exists in that field and this is the position people are taking, is recognizing the fact that there is no one position in psychology either. Which one speaks to you and why is one kind of a thing, but to sit there and sort of say, now that I want to do unsoundness of mind, I'm going to become a psychologist, psychiatrist, and all rolled in one, is kind of remaining neither here nor there. The question that is a bit more important for us as law people is, why the blessed hell are we concerned with unsoundness of mind? What is it that, as legal professionals, we have to be confronted with in doing unsoundness of mind? And if is the whole construct of unsoundness of mind, in a manner speaking, adding the coercion of the law to the expert knowledge possessed by the other discipline, but the other discipline doesn't have that kind of compulsion that whatever it thinks or means, it can actually force it down people's throat. That power is only possessed by law. So how skeptical we are of other knowledges when you want to superimpose the power of law on it, for me, that's the more important question, Parth. Because as law people, whatever we say is the meaning. We are the only ones, the only discipline, which can actually put the force of the state and the police and what have you behind whatever we think is knowledge on a specific issue. Other disciplines don't have that. How you process and what you want to be celebrating in those disciplines or not, we'll go back to the first slide I had shown, that your perspective will determine your methodology.
Question from Sandipta Padhi.
I have a doubt that we have perspective about the issues we are researching about. But while conducting the research, would you advise to separate that from the current research question and then amalgamate that perspective in conclusions, or keep aware? I would say keep aware the perspective throughout. You can't possibly, go around doing your analysis and finding materials without that perspective. To come to it, doing it in conclusion is like somewhere doing too little too late. Whereas if you keep the perspective alive, you're going to find that, new pathways will keep developing, other subparts will open up. The complexity of what you're researching will hit you on a constant basis if you keep your perspective alive.
Alaka Samal.
Yeah.
How to go for literature review in case of original research?
Have to go to a literature review, to find out what is not done. For you to find out what is going to be original, you need to know what exists. No?
Ma'am, if you permit me, I have a personal question, ma'am, like if I am allowed.
Yeah, sure. But why is Mr. Suripalli's thing you are not wanting, you want to jump him, huh? Then we come to you, because you are moderator. Yes, you come last.
Yes.
Finis' theory of law discusses how the state treats marriage and sodomitical relation supports the states recognizing same-sex marriage as the state recognizes non-consummated marriage as long as a partner. Don't you think, respected Dr. Professor Amita Dhanda, madam, that Aquina's theory prevails over Finis? I don't understand. I think you were the one who asked me the other question also. You seem to specialize in questions which are oblique to the topic. I don't hold positions in everything, sir. And I frankly don't understand why are you asking me this question. As deep as you want to, but not Parth, I'm answering you to sort of, when you're talking in terms of artificial intelligence should be a legal person. I am, interestingly, at this point, teaching a course on legal personhood at NALSAR. And amongst one of the areas which I am going to be considering is the whole phenomena of artificial, the AI person, or the developments that have happened in the real realm of biotechnology and what it does to personhood. But the way I have seen it, Parth, and I can just share that, is that I have always felt that knowledge as such is like, it is domainless, it kind of, but evidently all of us enter from different entry points. And if you enter from different entry points, at least the discipline from which you come, that is one particular thread you shouldn't give up. You should keep holding it, because if you leave that, then the other discipline is something which is new to you. The one which you knew, you left off that thread, and so you're nowhere person. I would somewhere say you keep your legal, your legal connections going, and then see how the other discipline speaks to you. And I don't think that there is such a thing as how deep. It's like as deep as you can go. And that always changes for all of us, as it's like when you start swimming, you kind of swim, wherein firstly in the shallow waters, then how much in the deep waters you're willing to go or not is something which, as your own swimming capabilities improve, you can go deeper and there is no such thing as that you learn another discipline only if you go and get yourself a degree in it. You have learned how to study. How much review of literature reading has to be done by an LLM student? Actually speaking, an LLM dissertation is only a literature review. That's what you are doing. You're picking up an area and you are trying to find out all that people have written in it, and you're presenting it in a coherent and logical manner. Whereas when you're doing a PhD, you're doing a literature review to find out what people have not done, and which is where you have to be contributing. There's two very different kind of purposes. A literature review in an LLM, a dissertation is virtually a literature review. It's just that how do you present that literature review in an attractive, coherent manner? Whereas when you are doing a PhD, you're doing a literature review to find out what has not been done. How generative would this research be, Matlab? How to overcome the difficulty of generalizing my finding based on the observation of listed companies, as few of them are insider dominant and others are not. So at this juncture, how can I come to a correct conclusion? You have to, Naglakshmi, in any kind of research, you can only generalize as much as the data you have gone through. If you have not studied something, you evidently can't generalize on it, and you have to say so. It's a first principle of any honest, authentic research. If you have not done something, you have to say that I have only done this much. And hence, whatever I have to say can only speak for this much. If I've analyzed only 5 inches, I cannot generalize for miles. Yes, Irfan, let's come to your question.
Ma'am, there is a request from Nandini, ma'am. I actually skipped her question, which was in the beginning. So I will ask that first, ma'am, if you permit.
Okay, you're being a good, honest fellow, huh? Chalo, theek.
Yes. Yes,
I can't find it.
Yeah, is it mandatory to follow a certain school, or can there be a combination of schools to choose a method?
There's nothing mandatory. It's like, that is the point when I was, Nandini, when I was making that point about perspective and methodology. What I basically, I can tell you for myself, like I do this combination, say, between feminism and critical race. Or like you would, you can at a certain point of time pick up maybe certain things. Increasingly nowadays, I'm finding that I need to be a very good positivist, because positivism has this big advantage of that it requires people sitting in authority. It says that if you want to be doing certain things, you can do it this way or not at all. And considering it is very rule bound and it's very explicit and it's very black letter, I find that the way in which it circumscribes power, no other school of thought does it with equal power. But doesn't mean that I have then become a positivist, because there's a whole range of positivist rules with which I have fundamental disagreement. So I would say that no, I mean, if you are making a rule by which, you are privileging, say, certain languages and keeping some other out, my entire commitment, say, to people who have languages not protected by the Constitution, but which is their driving force. And if you say language is what makes for identity, then I'm not a positivist there, I'm definitely a critical race theorist. So it's like, I would definitely say, be eclectic and pick and choose and see what is it that helps you in what you're getting to do. It's not like, it's not like a signing in for some degree or signing in for some specialized course that once you have signed in, you can't get out of it. It's about you thinking. And, there's schools of thought, just as one other thing, Nandini, the schools of thought is ultimately just a convenient way that people had found to teach jurisprudence. It's not something which has been legislated. In fact, a lot of people who are put into one school may well get up and say, no, I don't really belong to the school of thought. It's a superimposition that has been done on them by other people. So you can do your own combination and say, okay, this in bell hooks appeals to me, and that I find Dworkin very persuasive. So it depends upon what you are studying and how your own evolution as a scholar is happening. What I'm, in fact, trying to do when I'm talking about original research, I'm saying is that one of the first rules of scholarship, any scholarship, doesn't matter at which level, at LLB, LLM, PhD, postdoc, what have you, is about taking yourself seriously as a scholar. Seriously meaning, okay, every body of knowledge which you study or you examine, you don't defer over that person. That you have to say, okay, how persuasive, how convinced are you? And even if you're wrong, it's okay, because that's what it is all about. When you talk about original research, you firstly sign in and say, I am coming in as a person who has her or his own scholarly credentials. And you may come with all the celebrity and you may come with all the publications, but I come with my own mind and I'm going to relate or interact with you from there. Without doing that, none of us can really do any research, original or not. And a large part of why we are hesitant to do original research is because we feel, but I don't really know so much, They have written so many books and that person is kind of so famous. So maybe I am not too right. And in our not giving ourselves that sort of acknowledgement and validation, that's where we kill our own scholarship. I am just trying to tell you nonsense. You take yourself seriously first. If you take yourself seriously, the rest follows. And what the blessed hell, even if you make a misjudgment or you make a mistake, you correct it. It's a part of any growing up on anything, is that you should be able to make your mistakes and live from them. No? How generative is it to look at a legal question from the point of view of the theoretical justification of that subject? Example, to look at the question of copyrightability of AI artwork. How generative is it to look at the question from the theoretical justification of intellectual property law, like as opposed to looking at it, the question from a purely doctrinal point of view, like case law? Both options are open to you, Parth. It's not like one cancels out the other.
Ma'am, like particularly in PhD research, ma'am, as you have pointed out in the presentation, there are many ramifications, even intra-discipline and interdiscipline of the topic which we have chosen. like what would be the limit to which we curtail ourselves, ma'am? Because it's how do we stop ourselves? Like it's an unending journey.
That's true. That's
Yes,
true.
ma'am.
I mean, see, the thing is, okay, maybe because I was so busy in trying to show you pathways from which you can enter, I did not say that you have to enter through all of them. You can limit yourself to any one. There is nothing at all preventing you from doing that, Irfan. The point is only this much, that whichever pathway you enter from, then don't try to kind of make it too limited. I was saying, okay, you want to do a positivist examination, do it. But then at least do a deep positivist examination. So you can actually, when you scope, especially, see, when you're doing your postdoc work, after your doctorate is done and you're writing your books and all that stuff, you do what you will. But I always tell all my students, Irfan, that PhD is not your lifetime work. It is, at the end of the day, it's a degree. And hence it needs to be approached like any other degree. It is something that you have, it's a task that you have to perform. So, and you have a time limit within which you have to perform it. So considering you have a time limit within which you have to perform it, it's only sensible that you kind of cut your task to your time. And if you cut your task to your time, then you can say, okay, is it empirical research I wish to do? Is my area or topic such that unless I do empirical research, nothing worthwhile is going to happen? Or is it that, yes, the doctrinal research in this area is also like so very meager, that that's what I'm going to do because that's something I can do conveniently in 3.5, 4 years or 2.5, 3 years, whatever you see as your time frame. So these are options available to you. I am not at all saying that you have to take all of them.
Yeah,
But
yes,
you
ma'am. Understood, ma'am. Thank
Yeah,
you so much.
Yeah, you have to work it out in such a manner that you say, okay, this is the focus of my study. And this, if I'm going to take this route, then these are the range of things I need to do along with it for me to do worthwhile work. That's the point, basically.
Okay, ma'am. Thank you so much, ma'am, for your patient answering of all the questions.
All the participants have got enriched themselves by the lecture and to do how, in spite of the fact that most of them in the participation are PhDs and some of them are pursuing their LLMs. So it's going to be a very good insight for all of them. In spite of our PhDs, still after listening to your lecture, we are just trying to put ourselves a question. So many different dimensions you have shown us. Something. It's again a kind of thought-provoking process have started, especially in my mind also. In spite of so many years of my PhD and doing my research. Thank you so much, ma'am. It is really enlightening. And I'm sure all the participants and everyone who are listening to a lecture have gained a lot. And of course, they'll definitely will look into the different, will enhance their perspectives in case if they are doing their masters or pursuing their PhD. Thank you so much, ma'am, for consenting, for giving your consent, for being a part of this program. It meant a lot for all of us. Thank you so much, ma'am.
Thank you, Radhika. It was a pleasure. And I must say that, I have to say that, the questions were, I had my disagreement with Surapalli Sab, but other than that, I presume he has a logic for why he is asking if maybe I am not comprehending, or because he's asking me very core substantive questions and I'm doing a methodology lecture, so I'm a little bit thrown. And I'm also voicing this because somewhere I feel that these are dialogues, Radhika, we must have. Even disagreeing with the questioner and saying, why are you asking me this, is about the fact of that both of us should think about it, is what is it that he was asking to us.
Exactly.
So I am really, really thankful to all of you for so like, what is it called? Energetically engaging with me. And that's the fun part of any lecture. You know, it's like if the audience is with you, then it's fun. Otherwise, to bore ho jate na. It's like,
Yes, exactly, ma'am. Thank you so much. It's so nice of you.
Thank you, Vijayalakshmi ji. Thank you so much.
Thank you, ma'am. Thank you so much, ma'am. Thank you on behalf of all the participants and our staff and University College of Law. We are very much thankful for you, ma'am, for accepting and giving such a nice presentation on this particular topic, ma'am. Thank you so much, ma'am.
Thank you, Vijayalakshmi. Thank you, Radhika. Bye-bye.